The National Coloured Congress leader and Member of Parliament, Fadiel was set to testify before the Madlanga Commission of Inquiry today. But the latest news coming through from the Commission is that the evidence leaders may request a postponement after only receiving Adams's affidavit late last night. Now, Adams was scheduled to appear under subpoena after initially being served with a Rule 3 notice in October last year. Adams's testimony will be over allegations contained in the whistleblower complaint that triggered an investigation into senior crime intelligence officials. The Commission has in recent weeks heard evidence from current and former Investigating Directorate Against Corruption, that's IDAC officials, about the origins of Adams's Section 27 referral, which prompted investigations into senior police officers and has also become a central focus of the inquiry. Now, to discuss this matter further, we are joined now by constitutional law expert, Professor Pierre de Vos. Professor de Vos, thanks so much for your time. Welcome to Morning Live.
Good morning. Thanks for having me.
I just want to start on looking at the trend that we've seen, especially in phase 2 of the Madlanga Commission of Inquiry, where we've seen witnesses resisting or delaying their appearances. Now, where's the line between a person's constitutional right and the Commission's right to obtain evidence from them?
Yes, obviously, if you're going to appear before the Commission and you might implicate yourself, you have certain rights and you have right to legal representation. But if you're subpoenaed, you have to testify. There are ways in which some of the witnesses have tried to avoid that by falling conveniently ill at the right time and so on, through doing other delays. But at the end of the day, they cannot refuse to testify. If they do, it would be contempt and they could be imprisoned for that. So the Commission has been relatively successful in not allowing this to get too out of hand by making sure that people's rights are respected, but at the same time being firm and making sure that the excuses that are given are in fact valid excuses, as we have seen with the case of Mr. Karim, who has now been ordered to testify on Friday, I think, unless he submits himself voluntarily to further medical investigation.
And that, of course, is what has made this particular week so interesting for the Madlanga Commission, given the high level of people who are set to make appearances. But then, of course, there's also been the question of referrals that have been made for possible criminal investigation. So what is the legal significance of such referrals, and how does that differ from the Commission itself making a finding of criminal guilt?
Yes, so Commission of Inquiry is not a court of law. It's not a criminal court. It cannot make criminal findings of criminal guilt against anyone. It can draw conclusions. It can make findings. Those findings are not legally binding in the sense that it has immediate direct consequences for everyone. That is why if there's going to be criminal guilt established, it has to be done through the normal criminal justice process. So there must be an investigation and then there must be a prosecution. So that's why there's now the referrals, so that it can be investigated. Hopefully, it's a special team investigating this, so hopefully it will be more efficient than some of the other investigations sometimes done by the police services. And then there has to be a prosecution, and you'll have to prove beyond a reasonable doubt that the person is guilty for that person to be convicted by the court of law. That is still that takes a long time, and in that process, unlike with the Madlanga Commission, the accused person will have all the benefits of the criminal justice systems and the protections, and can use those to delay, as we have seen many accused persons have done in the court. So it is still a long way off before anybody is going to be convicted, I think.
And then the constitutional duty of President Cyril Ramaphosa, given what the Commission has or maybe may still find, especially when it comes to wrongdoing of senior people in the South African Police Service and other entities that they are probing.
Well, some of so the head of the Police Service Commission, National Commissioner, is appointed by the President and can be removed by the President, but only after there has been an inquiry as prescribed by the law. The other members of the police services are usually under the authority of the Police Commissioner. There are certain procedures for removal, except for Deputy Commissioners. So that process can happen independent of whether there's a criminal conviction or not. People can be removed from office for wrongdoing. That wrongdoing doesn't have to be criminal offences that was proven beyond reasonable doubt. So to what extent, some people have already been dismissed or have resigned. So to what extent that will continue, we will have to see, and that depends also on the political will, of course, of the leadership of the police service.
And then, of course, there's the matter of the Minister of Police, who's still on suspension, Minister Senzo Mchunu, and that raises the question of, again, the President's obligation in this regard.
Yes, so this is a political accountability matter, it seems to me. There's not necessarily an enforceable constitutional obligation, but if the President says he's really strongly opposed to corruption, if somebody within his cabinet is implicated in wrongdoing and he doesn't immediately and forcefully respond and dismisses the person, which he can do, it's a political decision, you don't have to have a disciplinary hearing or anything like that, then the voters, of course, will be well placed and to make their judgment on this. And to judge also the party that the President belongs to. So yes, so for me it's important for voters not to fall for that claim that the President has to follow processes and procedures when it comes to the appointment and the firing of cabinet ministers. He can do so without any of that. There is no legal impediment to him acting against anybody who has been implicated in wrongdoing.
And interesting you say that, because the President has been saying that he's going to wait for this commission to conclude its work and before he actually makes that particular decision. But of course, constitutionally, he doesn't have to wait.
No, yes, that is correct. In fact, the whole idea of this having a minister on suspension is dubious from a constitutional perspective. It's not clear that there is such a power, but assuming that there is, it's a political choice that the President is making to not remove the minister from office, and from the perspective of somebody from the outside, it is a curious decision for somebody who claims to be really committed to eradicate corruption and wrongdoing and unlawful action within the government.
And then, of course, there's also Parliament and Parliament's constitutional obligation, Prof. De Vos, because we heard in the Zondo Commission where Parliament also came in for a bit of a lashing in terms of its oversight role and responsibility. If we look at what is being uncovered now at the Madlanga Commission in terms of the police and what's been going on there, how much responsibility should Parliament bear in terms of its oversight or lack thereof of what was happening in the police?
Yes, so Parliament obviously has a constitutional obligation. It's a positive obligation. The court has already ruled in several cases against Parliament for failing to hold the executive accountable. That accountability is not only impeachment of the President. The Parliament can say have a vote of no confidence in the whole cabinet, and then force the President to reconstitute the cabinet and not include people in the cabinet that have been involved or that has been implicated somehow in wrongdoing. And of course, they can also have the kind of ad hoc committee process that they did in as regards the police is concerned. But as many commentators have pointed out, that committee has not really been very effective. That's maybe because of the politics involved, and that's a difficulty for Parliament, because it's also made up of politicians with political interest, and so that accountability is going to be subjected, or the earnestness and the eagerness of individual members of the National Assembly to hold the executive accountable depends on their party loyalties and many other things.
And just coming back to today, and of course, we were expecting the National Coloured Congress leader and Member of Parliament, Fadiel Adams, to appear before the Commission. Firstly, just your reaction to the request for a postponement for Adams's testimony, and we expect that it would be the evidence leaders who will ask for this postponement based on the fact that they only received the sworn affidavit and, of course, other annexures from Adams after 9 p.m. last night.
Well, it is maybe not surprising, because we see that especially witnesses who might or seem to be rather concerned about going to the Commission, given the way and the effective way in which the Commission has uncovered the truth and has caught people out in dishonesty before the Commission. It's not that surprising that there would be attempts at delay. It's not acceptable, because Mr. Adams was already given a notice, I think, how many months ago? So it looks from the outside, we don't know if there's other factors that we're not aware of, but it looks like a delaying tactic. If it was another legal process, I would have been concerned that Mr. Adams might get away with it, so to speak, but the Madlanga Commission, as I said in the beginning, has been relatively good in curtailing these kind of uses or exploitation of procedural rules to delay or indefinitely delay the testimony before the Commission.
Interesting. You should say that, because I think much of South Africa at this point will say, in Madlanga we trust. You know, that's eventually we will get to where it needs to get. But of course, Adams claimed that he obtained classified intelligence documents that were slid under the door of his parliamentary office. Now, how does the law then handle evidence that is illegally obtained, or, you know, in the case of Mr. Adams, where he would say it was slipped under his door, or it was otherwise leaked? You know, how does the law deal with that? And subsequent Section 27 whistleblower affidavit that was deposed by Fadiel Adams in this regard?
Yes, so this is tricky. This is a tricky area. Obviously, Mr. Adams, the most obvious response would have been for him to share this information with the Inspector of Intelligence, the Inspector General of Intelligence, who's now suspended, and to follow formal channels. He hasn't done that. So depending what these documents are and how classified they are, it might be a criminal offence to remain in possession of these documents. I'm not sure exactly what the classification is. And he has obviously followed another route, and that, I think it's one of the things that will be explored before the Madlanga Commission, is whether he was entitled to hold on to that documentation, and why, maybe not criminal matter, but why he chose the route that he did, and if there was ulterior purpose, whether he was part of some kind of nefarious plot, or he's just an innocent, bumbling person who didn't know what he was doing.
And again, just staying with that point, Prof, evidence before the Commission suggests that IDAC investigators may have relied, and rather heavily so, on this perhaps improperly obtained evidence by Fadiel Adams. So they use that to then pursue very high-ranking police officials, generals in this case. So what is the constitutional implication if you have an elite investigating body like IDAC using questionable or perhaps unauthorized intelligence material to conduct this Operation Diversion, as it was dubbed, against senior law enforcement officers?
Well, judging from the IDAC testimony before the commission, there wasn't really anything in Mr. Adams's affidavit. They were just hearsay, allegations, conjecture. There was no evidence there. So in a way, the problem is not that he relied on secret information, is that there wasn't any evidence whatsoever, at least not based on this. And so obviously this raises huge questions and red flags about the IDAC and what he did. And it raises the bigger question. On the one hand, when you have an anti-corruption fighting body, it's absolutely imperative that that body should be independent. But when it's independent and it is in the wrong hands, it can be abused. And so I think going forward, we have to think very carefully how we create a corruption fighting body that is powerful and independent, but where there is also checks and balances, not including the politicians, but checks and balances, maybe with a beefed up inspecting judge or whatever that can oversee the body, to prevent the kind of thing that happened here with Andrea Johnson, of seemingly using the powers in a way that was not above board. And that is a problem. So there's a tension between the independence and also making sure there's accountability, because if the wrong kind of accountability will then open the door for that body to be captured by the politicians, which is also a problem.
Just a quick one, Prof. What would you say is the single biggest constitutional concern or lesson that has emerged from the Madlanga Commission so far?
For me, it's a broader concern, which is not only dealing with the police force, but the whole public administration. And that is that the importance of these bodies not being politicized and politically captured, so to speak. So that the bodies, all the administration, but the police particularly, is a professional body, someone that is not going to be run for political gain, and where people are not going to be appointed or promoted based on their party loyalties, because that is a recipe for disaster, for disaster, not only for the fight against corruption, but the general fight against crime.
Professor Pierre de Vos, thanks so much for your time, constitutional law expert, speaking to us about the Madlanga Commission of Inquiry and, of course, Fadiel Adams's expected testimony today that may not go ahead because of recent developments.